Good evening, ma'am. I'm Dr. Sangita Laha.
Good evening, ma'am. Good evening.
Hello. Oh, it is requested to everyone to please mute themselves.
Am I audible?
Yes, sir,
Professor
you are
Sarfaraz.
audible.
Okay, perfect.
So we have all the panelists here with us. I request the panelists to please put their video on. And all the participants to please keep their video and audio off.
Sir, I have a request.
सर मेरा कोर्स वर्क चल रहा है
Oh,
and they are asking me to sit for scrutiny. And then course work is already called.
So we will start with the webinar. Greetings of the day, Professor Dr. Sarfaraz Ahmed Khan, Professor Dr. Dilip Uke, Professor Dr. Anil Warrior, Mr. Siddaq, Preet Singh, respected panelists, and my dear friends. I, Manisha Katyal, convener of Center for Research in Criminal Justice, welcomes you to session 7 of Criminal Justice Talks, which is a panel discussion organized in association with Team Samaanta of Thapar School of Management on the theme of gender equality. This discussion aims to reflect a growing interest in the criminal law's treatment of different genders, both as victim and as the offender. This webinar is organized by Center for Research in Criminal Justice, Maharashtra National Law University, Mumbai. Center for Research in Criminal Justice was established to promote and advance the national and comparative research and scholarship in the area of criminal law and criminal justice, and human rights. The center works towards carrying out coordinated research into the efficacy and adequacy of criminal justice system in India and communicate the finding and recommendation to the agencies of government concerned with the same. To talk about Team Samaanta, the name itself speaks for it. Samaanta Foundation is an initiative that aims to promote the equality and empowerment. We believe in equality fellow equally regardless of the gender. We believe that gender equality is not the only fundamental human right, but a necessary foundation for peaceful, prosperous, and sustainable world. So, Team Samaanta is trying to bring change and make the society Saman. With that intention in the mind, the panel discussion was scheduled. I would like to thank Professor Dr. Dilip Uke, Vice Chancellor of MNLU Mumbai, Professor Dr. Anil Warrior, Registrar of MNLU Mumbai and Director of Center for Research in Criminal Justice, Mr. Siddaq Patel, Siddaq Preet Singh, who is the Instructor and Facilitator of Sustainability in Practice of Thapar School of Management, for providing us with the opportunity, platform, and resources for organizing this session. Without any further delay, let me introduce to you our esteemed panelists we have today. First, we have Professor Dr. Sarfaraz Ahmed Khan. Sir is the present director of SLS Hyderabad and is having almost 2 decades of experience as law teacher and researcher. Formerly, he was teaching at the West Bengal National University of Juridical Sciences, where he has also served as the acting registrar for nearly 2 years. Subsequent thereto, he joined MNLU Mumbai as the associate professor. He has been awarded several scholarships, including the British Chevening Scholarship to pursue his second LLM at University of Essex, Hong Kong UGC Scholarship to pursue his PhD at City University of Hong Kong and Michigan, Gratuitous Research Fellowship to Michigan Law School. He has also been awarded the International Visitor Leadership Program Fellowship by Department of State, USA on human trafficking in the year 2007. Today, Sir joined with us as a chief guest and also as a panelist. We welcome you, Sir. Next, we have with us Dr. Sangita Laha. Ma'am has done MA Political Science, MBA in Marketing, LLB and LLM in Hindu Law from Patna University. Further, she completed her PhD in Law and Gender Justice from University of Calcutta. She has published the book titled Women and Legal Profession in reference to the Indian context. In 2014, she was Assistant Professor in West Bengal National Juridical Sciences, Kolkata, Chanakya National Law University, Patna, and has worked in Amity Law School, Lucknow, as a professor and deputy director, where she was guiding the PhD scholars apart from teaching. Currently, she is the associate professor since 2018 in National Law University, Ranchi. We welcome you, ma'am.
Namaskar and thank you.
Then we have with us Professor Dr. Bikram Das, who is involved in profession of teaching from last 35 years, which include both UG and PG teaching. He obtained his degree of LLM from Bombay University and ML degree from Annamalai University. He did his PhD from Sambalpur University, Odisha. He is founding course coordinator of BBA LLB honors and working coordinator of PG, DIR and PM courses. He has guided several PhD scholars. Under his names, there are more than 60 research articles published in national as well as international journals. He authored 2 books on juvenile justice and legal education and research. He also co-authored the book on right to information. We welcome you, sir.
Thank you, ma'am.
We also have with us Ms. Charusheela Chandrasekhar Khairnar, ma'am, who did her BSc in microbiology, LLM in human rights, and NET in criminology. Presently, ma'am is doing PhD in rights of women working in organized sector. Ma'am is currently the vice principal of MVP Samaj Law College, Nashik. Ma'am has the experience of practicing in court for almost 10 years, and after working in the Nashik court, she started her profession of teaching, and it's been almost 16 years since she is teaching in a law school. Ma'am is the present executive member of Nashik District Legal Services Authority and also the member of Internal Complaint Committee of Nashik District. We welcome you, ma'am.
Thank you, madam. Thank you.
To start with the discussion, I would request Professor Dr. Sarfaraz Ahmed Khan to give 2 or 3 line introduction on our topic. Sir, please. Sir, you are on mute.
Okay, thank you, and it's a really honor to be here in today's programs and interacting with university, which is where I work, and my last appointment was working at MNLU, and it's very close to my heart. And this program, particularly when I was in MNLU, I was part of this center, so it's a great opportunity to connect with my own institutions and interact at this point of time. The present topic, when we are discussing about the gender equality in criminal law, definitely there are 2 kinds of views in which we can look into, and definitely in our discussions we can find out one, we do need gender equality undoubtedly, but at the same time, when the nature of offense or nature of wrong is when the women's or females become more victimized, so we require little differentiations as in mechanisms to provide justice to women. And similarly, other circumstances when we see on penology or other issues when women are being dealt with, There also, considering the nature of offences where the persons are involved, can penology see in the same way all kinds of offences or all kinds of punishment? So whether both the gender can get same kind of punishments or not, again, is the issue. So at the same time, what my view is, today deliberations will look into. We do require gender equality. At the same time, we need to ensure that the women or those who are more victimized in the present criminal systems, their sufficient protection should be provided. It could be by legislative mechanisms. It could be by virtue of a constitution has provided that opportunity for us. So we use that opportunity, and at the same time we provide and we ensure the protections of women. And we see the large number of cases like during the trial, the kinds of protection the women require, whether it's a Sakshi judgment, post Sakshi, in POCSO, the kinds of protection which are provided for it, it's essential. So we can't see from the point of view that when we say gender equality, each and every procedure within the criminal system should be same for male and female, depending on the situations, need, and the kinds of protections they require. So I wish today's deliberations will take into account all these issues, and we will discuss that. At the same time, our ultimate objectives will be gender equality within the criminal system, but at the same time we must be sensitive towards protections of women's rights and ensure that within our criminal systems the women are not more victimized. There are a few opening remarks which I would like to give at this point of time, and gradually during the panel discussion definitely I would like to share my further views. So thank you.
Thank you, sir. With that, I would like to start with Professor Dr. Bikram Kumar Das with my first question, that why are there different patterns of victimization for women and men, girls and boys, gay, bisexual, transgender, or any other gender we have? What would you like to say, sir?
Thank you, ma'am. I am very much happy that you have invited us to participate on such a beautiful topic, and that is gender inequality is a question that has been discussed throughout the human history, you can say. So gender roles are usually centered on certain conception of masculinity, femininity, or transgenders. So in that sense, a male, a female, they are having a different role in the society. Accordingly, that take the example of children, they should need certain separate treatment, that because they are having that they do not have sufficient mind, the conception of mind to commit certain crime. Therefore, in our society, we treat differently men as well as women, girls, boys, transgender. So separate differential treatment has been provided to them on the basis of human rights consideration. So in this context, if you see the different example, the person of social culture that ultimately augment for such a differentiation of punishment. So different kinds of victimization also. So coming to the gender equality, so discrimination is always treated as a valid one, because women, they are having separate role in the society, they are having separate status in the society. Male is also having a different status in the society. Similarly, children. So on the point of victimization, pattern of victimization for women, men, girls, and boys are different.
Thank you so much, sir. I would now like to ask Charusheela ma'am that how does gender affect the way that criminal justice system, medical personnel, and others respond to victimization, along with giving her introduction speech to our topic.
Thank you, madam. This topic is very relevant in the present time. I think since the ancient times, the various discriminations are there, but the gender discrimination is the most deeply rooted discrimination, and it's very hard to take it out. With gender discrimination, there are limited economic opportunities, social opportunities for women, and the most important thing, according to me, is the perpetrators, the persons who are doing this crime against women. They form the part of a very close circle of a woman. So I think almost 60 to 80% of the crimes are committed by the persons who are in the close circle of the woman, like her intimate partner or her family relations. When it comes to domestic violence or when it comes to sexual harassment, it is her job place. So definitely this topic is very important, and we have to understand the difference of the different pattern of victimization with respect to women and men. And we have to understand firstly how the crimes they affect a woman, how they make the women more vulnerable. And if we understand it properly, then only probably we can frame our criminal justice system in such a way that we can assure her a complete justice. And therefore, I think the criminal justice system, it consists of all the various elements which are involved from before the crime, after the crime, and till the punishment and the restitution of the woman. So there are so many persons who can form or contribute in the criminal justice system. So what is justice also has to be, I think, properly understood when it comes to women victims. So medical personnel particularly, they have their own problems, like the definition of the sexual offenses more particularly. The definition is so wide that sometimes even a very mm, genuine medical examination may be technically considered as under the definition of this, the rape. And therefore, the second thing is when the medical person is the first person who comes to know about the violence, the symptoms of violence with respect to women, and their role is many a times is constrained by the patients, the relatives, and the entire social outlook about the offenses against women. And so many times the medical personnels are also pressurized, or they are also the part of the same society. So they may also get carried away by the notions of justice of the persons. And so there can be limitations. Many a times we see that when it comes to offenses against women, the women themselves require a lot of time to come out of it and to acknowledge that the offense has happened against them. And when they are in their senses to acknowledge and to communicate what has happened with them, the second shock is with the family. Then the third shock is with the society. And then when they all decide to approach the justice system, by the time the most of the important things like important evidences may be may become useless or may become non productive or may not be giving the correct result. Many a times the society pressurizes, and the relationship between the victim and the accused, if it is a very close relation, then these persons are also helpless to take care of the victimization. So I think it's very difficult for the entire system to really respond to the offenses when it comes to offenses relating to women. Thank you.
Thank you so much, ma'am, for highlighting all the important aspects. Now, I would like to ask my next question to Sangita Laha ma'am, that how does the law affect people in different gender groups, and how do laws with differential effect come to be written and implemented? Ma'am, please.
Good evening. I'm first of all, I'm feeling honored to be in the panel with esteemed panelists who have such a long duration of teaching law, and I'm delighted to share the same platform with them. And I must thank National Law University Mumbai for giving me an opportunity to interact and to know from them also. The question that has been put to me is what we see is that gendered inequalities, stereotype roles, norms, values, and cultures of the society have not always been equal, as just now stated by my previous panelist. We had discrimination based on gender, and it was very commonplace in spite of the progress in many countries. Laws still exist that deny women the right to represent, even in matrimonial properties. So, such procedures, not only in criminal law, but you have in many other laws, where gender inequality is not an exception. Now, women did not even have the right to inherit property, and it was only when the feminist movement, the feminist women who asserted their rights, like Sucheta Kriplani, and few women who were during the who played a lot of role in independent India. In the independent India is where we got some equality by way of black letter doctrine. And those we eulogize as leaders of our freedom movement, were they gender neutral? I'm sure many of them are not. So we find a lot of inequality. Gender equality only came in when there was a second or third feminist movement that started in India. When first we had the laws, but we didn't know how to assert the law. We could not speak about our rights, leave alone to get property or any right, leave alone to take divorce from a husband, leave alone to take custody for our children, leave alone to even make a complaint or lodge an FIR. That was really unthinkable. So how can we say that laws were in favor of us? And even when we started having law in favor, it's only in 2013 when the criminal amendment came, only after the huge and cry of the Delhi gang rape case. Why is it so that laws should always be inserted in favor of women only when there's a hue and cry? It's only when Smita Irani, when she had gone to the, I think what I was reading, when she had gone to the Fab India store, and when she wanted to, take a rehearsal of the dress, that she found that there's a camera in that dressing room. And when she lodged a complaint, there was a hue and cry, and thereafter stalking and voyeurism and all these was introduced in criminal law. Why is it that it needs that there should be a hue and cry when any woman is affected? Why can law be gender neutral? And today, when we are asserting our rights, people say that why should it favor a woman? I mean, I'm surprised that after so many years of discrimination, of so many years, because we are raising our voice, the society says we are harsh women. We should not raise our voice, as if they have defined what feminine characteristics is. And this was apparent also in Air India versus Nargis Misra, when the Discriminatory Service Commission of the female employees to obtain a government permission before marriage, denying even a right to get married or the right to get pregnant, that was agitated in this case. Again, we have the Vishaka versus State of Rajasthan, wherein the Supreme Court brought some guidelines for equality in employment. Then we have Mackinnon, McKinsey and Company Limited versus Andre D. Costa case, where the court observed that there was a discrimination in payment of wages. of the lady stenographer, when both the lady and the male stenographers are working together in a similar condition, why they should be discriminated, why a woman employee should be paid less. Even today in India, whether it may be in academics, in politics, or it may be in medical profession, a woman has to work hard to establish herself. So if a man runs 50-meter a race, the woman has to run 80 meters of rest. And many of you might agree or might not disagree with my viewpoint, but that is the situation in India. If I have to work or if I have to travel abroad, I have to take a permission from my better half, from my husband. It is not vice versa. So discrimination has come from within, from not from the family to the society, to the government, and still we are not taken seriously, neither in employment, neither in decision of household affair. We always found that male should be the karta of the family. Have you heard any woman becoming the karta? Have any laws spoken about it? Women only started exerting her right or getting her property only after 1956, when the succession law came into being, and it is only lately, just 3 or 4 months back, that the daughter can claim a part in the co-pasture property in spite of whether the father is alive or not being alive. And we are talking about the 21st century. Don't you think law is still not discriminatory? Don't you think the Supreme Court has always to come across? Recently, triple talaq has also been made criminalized. And still we say we are equal. Still there is Article 14, 15 subclause 3, 16. Now, for how long should we suffer? That's my only question. And therefore, I find this topic is a very interesting topic that has been chosen up by National Law University, Mumbai, and have given me. So law in practice and law in letter are two different things. We might have law in letters, but to implement in practice, it's still a long way to go. Thank you.
Thank you so much, ma'am. With developing on your views, I would like to ask Vikram Kumar Das, sir, that do the patterns and type of illegal behavior differ by gender group, and if yes, then how?
Thank you, ma'am. The pattern and types of illegal behavior differ by gender group. So, if we consider this question, that gender roles influence a wide range of human behavior. So, in our society, we will find that different behaviors are used by the persons. So, in such cases, if a person is committing murder, so intention is required. So the type of intention that is required for male or female or whatever the group it may be, or even the transgender, they will form the same opinion. So it will not otherwise differ. So in my opinion, the pattern and types of illegal behavior differ by genders in certain minor offenses, because as Sangita Laha madam has stated, that women in our society is remain under privileged conditions since long. So at this moment, more than 7 decades we have crossed. That is, we are practicing a democracy, vibrant democracy. In our democracy, fundamental rights are there. Still, women are being discriminated. So in the family perception, she is nourished in a different way. So generally, she will not succumb to commit certain crime. Whereas in our male-dominated society, male may commit certain crimes. But so far their mental attitude is concerned, I never feel that pattern and types of illegal behavior that will differ among the gender groups. Thank you, ma'am.
Thank you so much, sir. I would now like to ask Professor Dr. Sarfaraz Ahmed Khan whether mitigating women sentence based on the family responsibilities may be paternalistic, and may perpetuate the female stereotype. There are sound historical support for this concern, and until recently, there was one case in which the woman's role in family determined the criminal sentence a court imposed on her. Defining the gender roles have been a major reason for gender equality in the society. Do you think that this factor of different treatment to genders in criminal justice system, and how?
Okay. To some extent, I agree to the extent that the women role in family should be considered as one of the mitigating circumstances. Now, why we are seeing this from the gender angle? We have to understand when in a sentencing processes, when the court has to decide on the punishment, court has always have a different parameters to decide how much punishment they will give. What criteria should be there? Why we have white-out punishment? Punishment is for the purpose of reformation. Punishment is, we are not retributive system where we are going to eye for eye. When we give punishment in any criminal law, when law says the punishment up to 10 years, it is completely discretion on the court to decide what quantum of punishment they can impose. Now, when they have to decide what quantum of punishment they can impose, in similarly situations, when a man, if court consider that the only earning member in the family, if the entire family will suffer in their absence, if he get much rigorous punishment or longer punishment, court used to be lenient. So when this leniency comes, seeing the similar circumstances in the male, we never challenge them, but in some circumstances, when these similar situations where a woman has to discharge their responsibility in family, and in a circumstances where court has given us lesser punishment, we see from the again gender perspective. The entire issue is when the idea of just punishment is for reformations. And we are giving punishment, what the really impact of the punishment will be on that person who is going to get punishment, whether it's a male and female. So we in my view, we cannot personally look from the point of view of the gender in the circumstances where might be court little given a lenient punishment to a woman who was having to discharge family responsibility. But we have to see from point of view what the ultimate objective the punishment will reach. If reaching that ultimate objectives of reformations, if the lesser punishment can serve the purpose, whether it's a woman or male, does not make much difference. Also, when we say this gender stereotyping issues are concerned, why the law required to be has different here in the law when we talk about punishment, it does not talk about separately. So far laws are concerned, in CRPC it's the same power, discretionary power is there to the court. CRPC, there's a in say session trial in 235 clause 2, there's a why we have a mandatory requirement for hearing an accused person on the point of sentence. The entire purpose of 235 clause 2 is that the court, before deciding on the quantum of punishment, court must understand what consequences will be of the punishment which they are going to impose, keeping ultimate objectives of criminal system that the accused need to reform. We need to think about punishment from a point of view of that if it is fulfill the objectives, court can consider that kind of punishment. Why Juvenile Justice Act, when we see it's talking about all alternative forms where the punishment can be given. So it's under the JJ Act, the concept is only 3 months special home, except in the present 2015 law where 16 to 18, one more steps are there. But otherwise, the whole idea is reformation. So if the court can reform, if the punishment helps in reformation of the victim, and if a victim is a female who has to serve the family, and court consider the lenient punishment is there, I don't think it's a right thing to see from the gender angle. Is basically from the point of view of the reformation. That's a larger context in which we give. Another thing, this issue which comes in many Western societies. When a female commit offense, the large number of offenses are which comes as a reaction to something wrong to done to them. And in those circumstances, they are being penalized or punished. Now, in those circumstances, they deserve to be lesser punishment because it was a reaction to something. So, in a domestic violence or intimate relationship, intimate partner violence, which are there in the family's domestic violence systems, where women might have committed wrong things to against the partner who was abusive, who committed wrong against. In those circumstances, if some point of time court is going to convict a female, the court has to see all these circumstances as one of the mitigating factor to decide on the quantum of punishment. So I personally don't see any kinds of wrong. I don't want to see from the point of view of point of view of gender, but I want to see from the point of view of if the sentence serve the purpose of ensuring justice and reformation of a women. I think that's the perfect thing which the court should do. And court has to look into account what circumstances in which a person has committed offense. If in the large number of offenses which female do, it's not that kinds of say masculining offense which we normally call murder, etc. is all which comes as a reaction to something which happened to the victims. And in those circumstances, if they are convicted, definitely court must look into rather to see how lenient punishment could be, because if it is fulfilling this purpose of reformations of the accused person, because that times of women is an accused, and accordingly the serve the purpose, I think there is nothing wrong in it. So when the question was, do you think this is a factor to different treatment to gender in the criminal systems? Can we see from that's the point, can we see from the gender point of view? The issue is if in the similarly situations, if a man who was victimized by the others and something they have done in retaliations, in the circumstances is different. There are many cases where if the person is a breadwinner, court do consider leniently. So ultimately, if the objective is fulfilled of reformations, then fair enough, it can be, we cannot different treatment. Yes, they can do different treatment if the objectives are different, is fulfilled of reformations to the by the criminal system. So that's my basic view. Yeah, thank you.
Thank you so much, sir. Moving on from the court's perspective, let me ask Charusheela ma'am that how does the gender of people who break the law influence their treatment by police, prosecutors, courts, and correctional program?
Yes, the gender of the offender does affect, because we have the idea of gender roles, and all these people who form part of the justice system, they come from the same society. So they are influenced by the patriarchal norms and gender roles, how a person is supposed to behave. And therefore, definitely, these people, they do have their own mindset to acknowledge the offense and to treat it as an offense, or how they are going to react to it, how they are going to punish it. Definitely, it has a close connection with the gender of the accused. Like we have socially acceptable behaviors, and therefore whenever the crime is assessed by these persons, even the starting from witnesses, prosecution, the judges, the correction homes, everyone, they have their own notions about the how a gender role has to be played by a particular person. And therefore, more particularly in offense, we find many a times that the women themselves are on trial before the accused, and they are questioned like, why you were at such an odd time in the company of so and so person. How was your dressing? What is your age? What is your caste? What is your race? What was the occasion for you to be at the place? And so many questions are asked to her. definitely the gender of the accused plays a very, very important role, because many a times I think there is a dichotomy when it comes to accepting the offense. Many a times we have the prejudice as to sometimes we take as a consideration, sometimes it is not considered. Like many a times while assessing the ingredients of the offense, many a times these agencies, they fail to consider the limited economics or social opportunities which are available to a woman, or the compelling social environment, family environment, or the limited opportunities or the compelling situations which has driven the person to commit that crime. And sometimes when it comes to punishing, or when it comes to correction, at that time such types of differences, gender differences, may or may not be considered. So many a times we find that the women, when they are accused, they are the first person on trial by the police, starting from the police, then the media, then the witnesses, the family, the society, and ultimately, obviously, when the witnesses, they say their own versions before the courts also are many a times may have a social or male dominated view of the matter. Therefore, we have now made the system more sensitive for the addressing the issues of the women, and therefore now we have made quite reforms in the system, and we have inculcated the provision for female police, female judges, female prosecutors, and better correction homes. But all these things, they uh, don't show that much effect in reality, because still we have to sensitize the people on the issues, and therefore I don't think that these persons, they do reflect the real justice. And therefore I feel that yes, the gender of the accused does plays a very important role. Like many a times the crimes which are committed by women, like the child abuse or uh, such uh, such kind of things, at that time the compelling social situation or the compelling family pressures, or her inability to cope up with the pressures of family and other things, are not taken care of or are not considered. And therefore sometimes her reaction to her inability to cope up with the situation may not be considered. And so in such situations her gender may not be considered, and that may cause the injustice to such person. Therefore I have this view that yes, definitely, when the women are in the courtroom or in the criminal justice system as an accused, they need to have a different type of sensitive approach towards them. Like in many of the initial cases about the sexual assault or outraging the modesty of the women, the judges had mentioned their opinion as nothing has happened actually, though there was an attempt, nothing, no damage has happened at all. So we'll find that the machinery has many a times failed to understand that even a threat or an attempt to commit the crimes against women or such things, they have a different impact on the woman. And therefore, when the man is there is being tried, and no damage is caused against the victim women of physical damage, then the many a times the machinery fails to understand the intensity of the crime. And therefore I do have the opinion that yes, the gender of the accused does play a very important role in analyzing the various essentials of crime, what the reasons of the crime or what has compelled the result. And definitely we need to have a different set of perceptions when it comes to women as maybe as accused or as a victim. Thank you.
Thank you so much, ma'am. So we have seen that the gender inequality do exist in our system of criminal justice. I would now like to ask Sangita Laha ma'am that judicial interpretation of the rape statutes ignore a great deal of violence in the women's life. Courts often require a showing of a serious physical injury in addition to the not permitted sexual activity. They will fail to see the men's latent threat of violence. Have you heard of the similar situation in rape cases where the men are victims? And what are your views on this?
See, gender neutrality is a simple recognition of reality. It is true, men sometimes fall victims to the same, or at least in a very similar act. Women have some women have also suffered. Now, but this is sometimes it is an anomaly. Most of the time in our society, per se, in India, we have heard rape constitutes who's raped? The woman or the girl is raped. I think it is in the rarest of rare cases that I have heard till today that the male have got raped. So, and then we are speaking of gender neutral rape laws. How do we speak of gender neutral rape laws when there are very 0.005 of incident of male getting raped? Whenever we are going after the house in our adolescent age, our mothers used to be strained. There was a freaky note on her forehead. Why? Will my daughter come safe or not? It never happened to my brother. It never happened to the son of the family. So, and then we are building an argument saying that rape laws needs to be neutral. Now, the very fact that the Criminal Law Amendment Act of 2013 came out with much deliberation, where the definition of section 375 was debated by different stakeholders, including the female stakeholders, that is the women stakeholders. And the definition, we have the POSCO Act, but sexual crimes against boys under 18 years are already covered by the POSCO Act. And once they become adults, they do not have any legal recourse. That is true. But rape laws, this definition of 375 has come after the amendment with much of deliberation. And then how do we expect that this will be a gender neutral law, especially gender specific rape law? Because here the perpetrator of offense can only be a man if you go with the definition of rape law. And therefore, the penetration can only be done by a man. It cannot be done by a woman. That is biologically it has been set. So how can women do the penetration part? If you look into the definition of the rape law, and I fail to appreciate that how it can be gender neutral. So therefore, the center government had to clarify its stand on the issue, particularly in the view of the recommendations of the Law Commission of India to make rape laws gender neutral. Although it admitted that the 172 report of the Commission recommended changing and widening the scope of rape law to make it gender neutral, by substituting the definition of rape, but I fail to understand with the definition that it now has, how can it how it can be made more more male centric, where male itself is an offender. So there I find that the ambit of rape law is still, to me, the constitutionality of Section 375 and 376, by saying that it is not gender neutral, to my mind, this cannot be the stand, and that's what I feel for the time being. Because where there is male who himself is an offender, how can justice be done? Of course, within the transgender community, I know there are a lot of abusiveness. There is, but when we take just simply a male and a female, I fail to appreciate that how it could be make gender neutrality. I mean, this is what I feel I have to say about this. Thank you.
Thank you so much, ma'am. My next question is for Professor Dr. Sarfaraz Khan. Sir, the judges decide whether a rape occurred by judging the men's entitlement to sexual access and women's entitlement to the law of protection. These judgments of entitlement depends on race and class as well as gender. So statutory rape laws protect only chaste and virtuous girls. Determination of whether girls fit this category depends on girls' sexual history and racial and other sexual stereotypes. What are your views on this and how this system can be changed?
Okay, thank you. Very interesting questions. But before going on these questions, just in continuity, I would like to say that this entire sexual offences, when law commissions suggested for gender neutral sex law, and followed by again Justice Verma committee report also suggested for their adoptions. In fact, one ordinance was there also. Now when we see these sexual offences, we have to see broadly from point of view that women can be exploited by other women, a man can be exploited by the other man, a man can be exploited by the women, a women can be exploited by the men. So there are LGBT community. There are so many angles are there, and accordingly, the time has come where we do need to consider on the that one aspect is the gender neutrality on the sexual offences. At the same time, parallelly, this entire earlier notions, when we see these kinds of victimizations and for women particularly, because in sexual offences, by and large, the victims are women. In those, when we see, it's a stereotype, and we look for always some different kinds of standard, different kinds of proof. But then we have come across, we have done quite long journey. So starting from like Mathura rape case, Tukaram, to the state of Punjab versus Gurmeet Singh case, where the girl was gang rape. In those circumstances, trial court convicted the accused, matter went to the High Court. High Court says that, look, how can after the event this gang rape incident girl has appeared for exam? And they create some kinds of doubt in the entire evidence of the victim. And then Supreme Court says that, look, trial court was in eye-to-eye contact with the victims and they are satisfied with the statement of the victims. How can you decide that the statement is not correct? So Gurmeet Singh case, again, we have come across quite a long journey in respect of the rape law. So by and large, the judicial interpretations in many cases are really significant to indicate that these barriers are limiting gradually. I also want to remind of the case of this Buddhadev Karmokar versus Shubhra Chakravarti, where it was a case where someone's accused went for under their jurisdictions for setting aside their FIR. then went to the Supreme Court against the girls with whom he has a relationship for longer time. So that's the issues where when we see the women, we see their kinds of consent, etc. These issues, and there the Supreme Court says that whether in relationship, whether there was a consent or not, this all trial court will decide. We are not here at the highest court to decide on the consent part. Court first time asked for some interim compensation in Buddhadev Karmokar case. Other aspects which comes also is in a situation where we always consider in some relationships the entitlement of a man to have a cohabitation with the wife. So the issue of marital rape. Now, this is another angle where we have to see how our laws need to be changed, and still there's a much more development need to take in place. So this marital exemption which are there in the laws, the exemption of marital rape stems from a long outdated notion of marriage which regarded wives as no more than the property of their husband. This notion has to go. We cannot think what was there 200 years ago. When we see the development, there is a huge development taking place in other part of the world. So in UK, R versus R case, which again further went to the European Court of Human Rights, where the CR versus United Kingdom, where court categorically says that the laws need to be recognized if we have to protect the rights of women. So marital rapes has to recognize. So this entire notion that the looking at that, okay, entitlement of a man to have some kinds of a cohabitation with a female, or then looking at from the point of a female about their background, character, etc. Now the shift has already been taken place. I have said from the Mathura to we come to the Gurmeet Singh case. So there are huge differences that have been taken place where if today's, according to judicial interpretations, if girls give a statement, there's no consent, there was no consent, he can be convicted, and it's proof in the Gurmeet Singh case where every accused persons were convicted. So a huge development has taken place, but yes, it's still in the mindsets it exists. When we see the trial court cases, the kinds of questions being asked by the trial defense lawyers, when we see the trial court cases, invariably some of the direction of the Supreme Courts are not being implied, like Shakshidism of a screen, etc. is not uniformly applicable in every place. When we see even smaller kinds of evidence, if you see a rape case record, and if you try to find out what the doctor says, now doctor says there was a rape, there was no rape. Doctor is not to decide a legal word. Doctor is there to decide to show what kinds of a penetration was there or not. So this one again is a gender stereotype where everyone consider that they are going to judge from a particular point of view or from the point of view of a female. So I think we have made lots of changes from earlier. We have developed our own jurisprudence, but yes, there are a few places where we require strong changes. One, law sexual offences to be gender neutral, marital rape has to go. This entire concept that if someone has a right over others for this sex, that is unacceptable, because the consent required merely because having some relationship, whether it's a marriage or legal relationship, does not automatically guarantee consent. So we need to look, and there's a need for much more reformations in the law, or might be through judicial interpretation. It might change in future. Well, when we see the European Court of Human Rights decision in CR versus United Kingdom, hope in Supreme Court sometimes they can just interpret it in the same way that consent has to be there, even in the this marital rape ground cannot exist. So in some cases, court has in fact said already, the Supreme Court in marital rape cases. So we require this entire notion need to change, and there's a requirement for some improvement there. So that's my view on it.
Thank you so much, sir. I would like to take one question which participants has posted. I would like to ask Professor Dr. Bikram Kumar Das that there is so much taboo around the rape of man, and the cases are not often reported, and we do not hear about them much. What are your views on that?
Please repeat the question.
Sir, the question is that is this possible that because there is a too much taboo around the rape of men, the cases are not often reported, and that is why we do not hear about them much?
Okay. There are certain studies of social attitude, so violence perceived is more or less serious depending on the gender victim and the perpetrator. Violence against women was about a third more likely to be reported, but in most of the cases, the male victims, their cases are not reported. Gender as a factor is the response of law enforcement system of violence against the partners. Mostly men are blamed, but women are not. But coming to the international sphere, that is Solange Mothan, a international law and criminalization. In 2013, he has made a study, and he argued that conflict scenarios of sexual violence against men has been ignored in favor of the focus on the sexual violence against women and children. So Richard Felson, he has made a detailed study, and he challenges that the assumption of violence against women is different, but most of the cases, the violence against men is not taken into consideration because in case of male victimization, Richard Felson said that some motive and intention plays a very much important role, and in the case of male victim never goes to the report the case, and in such cases the male victim ultimately will take into consideration that he's having masculine power. That's why it is not possible that a woman cannot cause any rape. You will see the definition of rape which has been provided in the 375, that women can also commit rape to the male members, but it has not oriented in that sense. So there are so many cases in the international sphere. The study has been made, and due to this social media, the things are coming out, and males are also being found victimized. So in my perception, that male victimization is not reported, and it is not taken seriously by the society so far.
Thank you so much, sir. As Sir rightly pointed out, that there are various studies which are presented and which are published. So I want to ask Sangita, Laha ma'am, that whether studying the biological predictions for criminal behavior is a way to seek gender equality in criminal law. Do you think that the biological explanation of crime often points to the wrong solution for the crime? And are the defenses in the cases where women are offender based on the women's illness, such as premature menstrual syndrome or postpartum depression, also risk in misogyny, have an effect on the punishment they receive? And also, do the stated facts affect in the making of laws?
Yes, the biological and physical variations do differ in women. For example, a woman of 30s may not suffer what a woman of 50 is suffering, because God has structured women biologically in such a manner that the symptoms of gynec problem may appear at different stages of life. So when she receives a punishment, the punishment, I'm not saying that women are not offenders, but the treatment for women has to be different, because emotionally, physically, and if she's a perpetrator to the crime, and she's given punishment, obviously it does have a role to play. Now, why she became a perpetrator to the crime, the court must also look into it. For example, if a woman is punished because of murder, it is also necessary to see as to why she became an offender to such a crime. And such women, if you go to the case analysis of such women, is that she herself has been a victim of domestic violence. And therefore, because she has become a victim of domestic violence, is, slowly and slowly her act of punishing her partner or some close member of the family has built up to the level of why she has done such an act. So I think that punishment, of course, is the same. We do talk of gender neutral laws, but at the same time, punishment should be made, or there's a high time that punishment should also be psychologically be should be taken into consideration. I'm not a psychologist, nor I am a versatile genius in criminal law side, but a peep into the background, the history, or the psyche of the offender, so far woman is concerned, should be taken into consideration. That is my view.
Thank you so much, ma'am. One question from the participant, which is PM Imran Khan approves chemical castration of the rapist in Pakistan, and the law is soon to be presented in the parliament. I would like to know your views on this particular fact. This question is to Charusheela, ma'am. Ma'am, you are not audible.
Actually, my my video has
Am I
also stopped.
audible now?
Yes,
Am
ma'am,
I
you are
audible?
audible.
Yeah. Can you please repeat the question? Sorry.
Sure, ma'am. So there is a news that PM Imran Khan approves the chemical castration of rapists in Pakistan, and the law is soon to be presented in the parliament. Ma'am, the Shubham wanted to know your views on the same.
I think rape is a very typical crime in our society. Usually, rape is not done for the sexual pleasures. Usually, it is done to harm the woman or her family, or to attack her honor or the honor of her family. So rape is not only for the sexual pleasure. Many a times, like you must have seen in Bhauri Devi case, the persons who raped her were of the age of her son, and the reason for raping was to teach her a lesson. So I think looking at the rape offenses and the punishment, this kind of punishment, which you can call it as retributive justice, it may not help in my opinion. And this punishment is also may be viewed by some people as again a barbaric punishment. So looking at rape, it's more or less punishing the accused is not a complete justice for the woman. Actually, a woman has to be there has to be a restitutive justice for women, because when there is a crime like rape which happens against a woman, the most damage which she suffers is not only physical and mental, but also her social image is disrupted, her family support is gone, her relations are gone, and so it becomes very difficult for the rape victim. And therefore, more or less in such situations, the focus, instead of just punishing the accused, the focus should be more on restitution of the victim, giving her a proper medical treatment, giving her the support for her life, giving her security, and making her or placing her in life again. That will be the real justice, in my opinion. Just punishing the accused is the focus of our accusatorial system. And we had initially that kind of outlook when we dealt with the various offenses under the criminal law. But now when it comes to offenses against women, this kind of approach is not sufficient. So we have to change our view, our penological view, and we have to see that the accused is punished. No doubt there has to be a deterrence, there has to be a prevention. So this may act as a preventive, but this punishment will help in, I think, the persons who are maniac, or some persons who do such kind of offenses because of their that kind of illness. But when the offenses of rape, they happen for various reasons, particularly in our society. And therefore, punishing the accused is one thing. It can be a physical punishment, like what he has stated, is a retributive kind of punishment. It may prevent the future crimes happening from that person, because the Crime Record Bureau shows that the person who commits a rape offense once and goes blot free may repeat such kind of offenses. So it may help such kind of control in such kind of offenses. But I think this is not a complete justice. We need to focus more on the victim and to see that she is restituted properly. And I think we have the compensatory jurisprudence also developing, and we are giving her the help, medical help, the shelter homes. Then we are trying to replace her in life. We are trying to repair her mental damage, emotional damage, physical damage, and to replace her in life. That should be the real justice, in my opinion. And one more thing, acceptance by the society. She has to be accepted by the society, by the family, as the victim. Many times, the victim of the rape herself is punished by the society, by her own relatives also. She loses not only her chastity, but she loses her relations, she loses her family, she loses her honor, the most important thing, the dignity of her life. And so the real justice should focus more on restituting a woman rather than just punishing the accused. No doubt punishing the accused in such way may deter the future offenders. Thank you.
Thank you so much, ma'am. You highlighted a very important point of accepting a person. With that, to build upon that, I would like to ask my next question to Professor Dr. Sarfaraz Khan, that some countries punish people for their sexual orientation or their gender identity with jail or even to death. It is extremely difficult and in most cases impossible for the LGBTQ people to live their lives freely and seek justice for abuses when the laws are not even on their side. Even after some countries have started recognizing them, they still have a huge fight to get their place with others. What are your recommendations for the same? Sir, you are on mute.
Okay, this is one important questions, and India from last few years we are seeing ups and down. So we have seen Naj Foundation case, which again overturned in Suresh Kaushal. Again, we comes to Navtej Johar case, where it requires recognize the right to privacy. And we have seen also the development subsequently in Nalsa case, where the LGBT communities, their reservation issues, OBC as in other backward class recognitions. So at least 4 important decisions which the Supreme Court has extensively discussed these issues. When we see at the international level, we have to see where we stand, and because these are all society's moral, which not changes in one day. it takes long time. So, and we to see how from where we have come, how we see at the issues globally. So, for me, it has to look from the point of view of the constitution. But just to have an idea, say for instance, when you say some countries are criminalized, yes, countries like Afghanistan, Brunei, Iran, Qatar, Saudi Arabia, United Arab Emirates, Yemen, it's even punishable, even sometimes punishable with death. On the other hand, some Islamic countries which are little liberal, Azerbaijan, Jordan, it's not punishable. In 2011, United Nations General Assembly has asked opinion for different members, and they're in support of same-sex marriage, etc. There's only few countries like Armenia, Georgia, Cyprus, Israel, South Korea, Japan, Mongolia, Nepal, Thailand, East Timor expressed their support, and later on joined by Vietnam and Philippines. Philippines is one of the country which has in that parameter is well diverse. LGBT communities are highly appreciated, and mainstreaming has been widely done. At the same time, in same United Nations platform, many countries like Indonesia, Malaysia, Brunei, Maldives, North Korea, Bangladesh, Pakistan, Iran, Iraq, Saudi Arabia, and others, they have all opposed. So when we see entire issues of rights of the LGBT people's freedom, I see from the point of view of their constitutional right granted by the constitutional article 21 to life and liberty. And from that point of view, whatever rights others are entitled to, they do require that rights. Many occasions when we see from the parameter of their backwardness, education's level, etc., in some of particularly some part of LGBT communities, NALSA judgment might help them in doing that. But more importantly, more than law, are we as a society is ready to accept? How much society is ready to accept this LGBT communities? How many streaming has been done? So there are some small initiatives here and there, like in some places in metro, they may work in the there. Some persons can do first time in West Bengal, a lady has become principal in a college. So we find some good examples, but as a whether that has completely changed or at a large, it has made difference in the entire society. So definitely from the point of view of today, after this Navtej Johar case, it's definitely is decriminalized. But yes, how far we are as a society, we are accepting it. How far this mainstreaming, where we can go, what are the other subsequent issues may come. We have to also think about all those. In same-sex relationships, women has a relations with women, constitutional rights they have, they granted it. Subsequently, what will be their property distributions? What will be the maintenance issues? There are many other issues are there. So while we have to see from the constitutional point of view, at the same time, we have to also look into how law will address all these challenges will come. Whether it's a challenge for taking adoptions, whether it's a challenge for property distribution, whether a challenge for maintenance. But yes, from my point of view, constitutions give granted to every individuals. As in every individual citizens, we have a right, and then accordingly, law should not, if the constitution has given some kinds of right to us, the law should not curtail that rights. And so in India, at least the position is, so far this 375 is concerned, we have our decisions where it's becomes is non-criminalized, but yes, again, same-sex marriage is not things. Are we ready for it? Are society going to accept it? It's a larger question. I don't have any personal view per se at this point of time, but I can only say that Constitution has granted every one of us right to life and liberty, and when we interpret right to life and liberty, which includes to have enjoyment of our life, live our life as per our wish and as per their dignity. So within that purview, definitely LGBTQ, that community will entitled to same kinds of protection which other peoples are entitled to. That's my view.
Thank you so much, sir. Because we have the time constraint, I would now like to take one or two questions from the participants. I would like to ask Dr. Vikram Kumar Das that the child marriage in India, according to Indian law, is a marriage where either the woman is below the age of 18 or man is below the age of 21. Now, according to Section 375 of IPC, in case of marital rape, sexual intercourse by a man with his own wife, the wife not being under the age of 15 years is not rape. Are these laws contradictory since getting any women married under 18 years of age would be a child marriage and which is illegal?
Thank you, ma'am. It's a very good question. Recently, the norm of law is taking a new course because we find that child should not be abused. So, in our own history, if we go to the Vedic civilization, the things were different. But if we come to the international sphere, now the law has been taking a new course because the age is a very much important factor. Because at the age of 21 or 18, the person's growth is not complete. So therefore, we take the stand the marriage should be done in a certain age, and even though marriage has been solemnized, so the husband ought to be punished on the context of marital rape. So the policy which has been developed today, I think it is a sound one, and it will provide a very good impetus for our country as well as the world. Thank you.
If I may add here, this Supreme Court in independent thought case, they have discussed on these issues, and marital rapes has been recognized as in rape. So again, marital relationship, the consent is required. So we have to see again this entire debate on marital rape from the point of view how the judicial interpretations comes in future. Yeah.
Thank you so much, sir. We had a great panel discussion on our theme. We have gathered various viewpoints on different themes regarding the gender equality. I would now like to ask Shubham to present the vote of thanks.
Thank you, Manisha. I, Shubham Mehta, on behalf of Team Samaanta, Thapar School of Management, and everyone present here, would like to thank and extend a heartiest thank you to our chief guest, Professor Dr. Sarfaraz Ahmed Khan, our panelist, Dr. Sangita Laha ma'am, Professor Dr. Bikram Kumar Das, and Ms. Charusheela Khairnar ma'am, for such an informative session. I would like to thank you all for taking out time from your schedule for this lecture and providing us with immense knowledge. I would also like to thank Professor Dr. Dilip Uke, Professor Dr. Anil Variat, and Mr. Siddaq Singh for giving us platform, constant support, and guidance to organize this panel discussion. I would also like to thank Center for Research of Criminal Justice, Maharashtra National Law University, for associating with Team Samaanta and providing us with such an golden opportunity. Last but not the least, I would also like to thank the participants for volunteering their time and showing their keen interest in this discussion in spite of all the technical difficulties we faced. Over to you, Manisha.
Thank you so much. I would now like to ask participants to please fill up the feedback form we have provided in the chat box before leaving. All the questions which the participants have posted in the chat box will be addressed via the mail. I would like to thank all the panelists for giving their valuable time and joining with us for these sessions. Thank you.
Thank you very much. Thank you. Thank you.
All
Thank you everyone, and
Thank you, madam.
Participants are requested to fill the feedback form before leaving.